All right, by far, the most common questions I get asked relate to penalties and building performance standards. So let's talk through a case study that sort of compares how Washington state law treats penalties and tenants and owners' relationship with respect to how the city of Seattle treats owners and tenants in that relationship, and whether or not you could pass penalties through, how tenants need to comply, etc. So looking first at Washington state law, sort of the overarching theme here is that utilities have to provide the building owners with aggregated monthly utility consumption data. No consent from tenants required. Doesn't matter how many tenants are in the building, none of that matters. Owners can get access to aggregated utility data. Okay. Then addressing penalties. Penalties due to noncompliance may not be passed along to tenants. Okay, specifically may not be passed along to tenants, but so long as tenants are providing access to utility usage data. I'm not sure why we would also need tenants to provide utility usage data. Maybe if for some reason the owner doesn't have access to it or they need suite level data. I'm not quite sure. If anybody knows, we'd love to hear that in the comments. As long as they're providing that, as long as they're providing physical access to physical spaces in the buildings and being responsive to needs from building owners to facilitate compliance with the standard. So those are pretty broad. We'll come back to that in a minute. But those are the requirements in order for owners to basically not be able to pass penalties through to tenants under Washington state law. So if you've seen any of my prior videos, you know that I've talked about how we're going through a rulemaking process here in Washington state. House Bill 1543, providing some additional flexibility, compliance pathways, and clarity regarding the current rules. So that's why this section here is in track changes, because it's just proposed language at this point. It may be finalized soon, but it gives us some insight into the issues we're talking about. So again, these would be proposed rules, which would basically align with the statute sort of broad requirements. So it tracks that same language here, and then the second sentence says the inability for tenants and building owners to find a mutually agreeable time is not being unresponsive. So that's not being unresponsive. It means something else. Building owners seeking relief through an exemption or exception must provide documentation of how the tenant is being unresponsive. So what's interesting to me is I don't see a specific existing or proposed exemption or exception that specifically relates to tenants not being responsive. But if someone knows where that comes from, I would love to see it. So please let me know in the comments. But interesting, that's sort of a call out of, hey, just not being able to find a time to meet does not constitute being non-responsive. Now, how does this intersect with leases? What you could consider doing is providing some specificity with respect to what this means in a lease, right? Not contradicting other legal requirements or what is in the statute or the rules, but instead maybe saying access to physical spaces, being clear about what that is. Does that mean during business hours? Does that mean not during business hours? Does that mean on 3 business days notice? What does that mean so that everybody can be sort of on the same page and has some clarity around that to avoid disputes later? Or what does it mean to be responsive to the needs of building owners to facilitate compliance? Or what does it mean to provide access to utility data? Does that mean in a specific format, a specific platform, whatever the case may be? So you could consider potentially putting some language in a lease that provides some clarity around what these vague terms mean, consistent with what the rules may add as well, to reduce disputes later. So that's how the state sort of handles that issue. Obviously, I'm pulling out kind of specific sections, but let's look at the city and sort of contrast that. The city definitely puts more of an onus on tenants. So kind of starting again at the top, tenants shall allow building owners access to mechanical systems and utility information as necessary to comply with our emission standard. So tenants have to do this. So if we drill down a little bit further, that's sort of the overarching theme, right? If we drill down a little bit further, fines for a failure of a building owner to comply, etc. However, no fine shall be imposed when the building owner cannot comply due to tenant's failure to provide information required under the section of the Seattle Municipal Code. So fining owners, but no fine shall be imposed when the owner basically can't comply due to tenant's failure to provide information. Okay, drilling down a little bit further, this is another section of that same section of the code. When failure to meet the greenhouse gas intensity targets, which is what we use here in Seattle, is due to tenant's failure to provide access to the mechanical systems, the director, the entity that could potentially impose fines, can adjust the fine amount imposed on the owner, considering the proportional impact on the building's compliance. So maybe a little bit of balancing or fairness there. Drilling down just a little bit further, if the director determines a tenant has failed to allow access to mechanical systems or provide utility information as required, the director may directly impose a fine on the tenant. So interesting here, ability to directly fine the tenant coming from the city as opposed to concerns related to passing penalties through. So if we drill down a little bit further, there's a director's rule basically that accompanies the Seattle Municipal Code, provides, tracks that same language, and then provides a schedule for tenant penalties. So to me, this reads as sort of a theme of more onus on tenants, at least than under the state statute, and more responsibility of tenants. So an interesting approach, kind of just comparing and contrasting the two. There's one more additional sort of aspect in Seattle's municipal code that I think is worth pointing out because it relates to leases. So if we drill down sort of a little bit further, the cover building has to meet the greenhouse gas intensity targets regardless of any changes in ownership or any lease agreements established after January 12th, 2024. I'm not sure where that date comes from, so if anybody knows, I would love to hear in the comments. But so that's sort of the high level. If we drill down a little bit, there's sort of some exceptions for extenuating circumstances where an owner can use basically an alternative compliance pathway, a decarbonization compliance plan, and one of the sort of sub-bullets of that is when the owner of a cover building has a tenant lease in place before January 12, 2024 that specifically precludes owner access to equipment on which work would be required to meet the greenhouse gas intensity target. So apparently there are some leases out there that specifically exclude owner access to certain equipment that would need to be accessed to comply with the standard. So, and that can only be, that sort of situation can only be used for the first compliance interval. So an interesting sort of specific lease call out in the Seattle Municipal Code, which if folks have any insight into that, I'd love to hear it. So just some interesting nuance with respect to Washington state law, how the city of Seattle is handling things. Hope that provides some clarity as well as some conversation around how we're handling penalties and how leases intersect with all of those issues. So love to hear from folks in the comments. Stay tuned for more.